Hello, good morning. We're just waiting for a few people to join onto the system before we make a start of the webinar. Thank you. Hello, good morning. We're just waiting for a few people to join on. Hello, good morning, good afternoon, wherever you're joining us from around the world. Welcome to day 2 of the ICC Annual Arbitration and ADR Conference. If you missed any of the sessions from day 1 from yesterday, you can get access via the online streaming tool Swapcard. All of the sessions from yesterday will be on there, as well as today's at the end of today as well. I also wanted to remind everyone that you can network in between sessions by visiting the platform. If you go onto the attendees tab, and you can get connected to over the 350 people now that are registered for the 3 days. We've got people attending from 45 different countries, so make the most of this opportunity to connect with people from all around the world. Without further ado, I'd like to introduce you to our moderator, Ian Quirk, who is our Vice Chair of the Arbitration and ADR Committee here in the UK. He will be moderating this session. Ian, over to you.
Thank you very much, and good morning, good afternoon, everyone, depending on where you are. This session is on reform of witness statement evidence in international arbitration. And the question that we are looking at is whether this is evolution or revolution. What we are going to do is a bit of a comparative analysis between how different jurisdictions, by which I mean institutions and the arbitral community, have in recent years become critical of current common practice with regards to the preparation and drafting of witness statements. And that raises several important issues which our speakers are going to address. Our speakers today are Charlie Carher of Wilmer Hale, who is a partner in the firm's litigation department and a member of the International Arbitration Group. He has a focus on disputes in energy, construction and aerospace, and depending on which of the legal directories you read, he is either highly intelligent or incredibly intelligent. Next speaker is Jeremy Glover of Fenwick Elliott. He is a partner specializing in construction, energy and engineering law. He is described for his part in the directories as someone with great attention to detail who keeps really calm under pressure. So we'll see if that proves to be correct at the question and answer session later. Anya George is our next speaker. She is a partner at Schellenberg Whitmer in Zurich. She is trilingual and a dual qualified lawyer in Switzerland and England. She has acted in over 60 arbitrations and also appears before the Swiss Supreme Court. Who's Who Legal says of her that she is one of the best of her generation worldwide. So we're very lucky to have her. And finally, last but not least, Rob Green, a training manager at Opus 2. He looks after client training on Opus 2's cloud-based trial system, and we are delighted to have him with us as well. There will be a question and answer session at the end. You can pose questions through the system, and then I will put them to our speakers. Be as controversial as you like. And let's see if we can put some pressure on Jeremy or any of the other speakers. So Charlie, can I start with you? You're a member of the ICC UK Arbitration Committee. So can you kick us off, please, with what the ICC Commission has had to say about witness statements and their potential reform?
Absolutely. Thank you very much, Ian, and good morning, everyone. The credibility of witnesses is a crucial factor in international arbitration. Arbitrators and counsel devote significant time and effort to establishing whether a witness is telling the truth. However, little attention has been paid to the question of whether honest witness evidence is indeed reliable. And that was the focus of the ICC Commission's task force and the report on the accuracy of fact witness memory in international arbitration that it produced. And I'd like to focus my presentation on that report. The starting point for the task force was a series of fascinating academic studies confirming that memories are not an objective, unyielding imprint of the past, but rather a subjective, pliable patchwork of experience, thoughts, and daydreams. And that rather poetic conclusion applies equally in the context of international arbitration. Now, the report discusses numerous and compelling examples of how memory is indeed malleable and can therefore be altered, contaminated, or distorted, including by how questions are asked. And just one example, and there's many examples, and I'd encourage you to look at these in the report. In an experiment, participants were shown a film and asked to estimate its length. Those who were asked how long is the movie answered with an average of 130 minutes. By contrast, those who were asked how short was the movie responded with an average of 100 minutes. The report sets out a series of practical measures that can reduce the impact of memory distortion in an international arbitration context. The task force was at pains to note that these measures were not rules or even best practice, but rather an open list for practitioners to consider and select as appropriate. The task force also noted that the measures are not intended to be one size fits all, but rather a menu to be selected from as appropriate. Now, two assumptions underpin that conclusion. First, witness evidence can serve a range of different purposes, many of which do not rely on the accuracy of witness memory. For example, witness statements are often used to provide undisputed background context, a technical explanation, or simply to put a human face to a party's story. Second, the task force recognized that some of the recommended measures may, in certain circumstances, prove impractical or even counterproductive in adducing reliable witness evidence that is of assistance to the tribunal. The task force also confirmed that it strived to highlight and address the risk of memory distortion in witness evidence should not lead to the conclusion that witness evidence is second best to contemporaneous documents. On the contrary, its initiative is designed to enhance the strength of witness evidence. Moving on to the recommendations themselves. The recommendations are made with in-house counsel, external counsel, and arbitrators in mind. In the interest of time, I don't intend to go through each one. And in any event, most of the recommendations are uncontroversial examples of good practice in collating and presenting witness evidence. Instead, I want to briefly categorize the recommendations. The first category seeks to minimize a witness's exposure to post-event information that might otherwise distort their memory. On that basis, the task force proposes that witnesses are interviewed individually, that they do not discuss their evidence with each other, and that witnesses specify the source of information if their evidence includes matters which they did not experience firsthand. The second category of recommendations focus on how counsel should formulate questions. The task force highlighted the need for impartiality when conducting witness interviews by avoiding setting out a party line. Interviewers should not reinforce tentative responses and follow-up questions. Instead, lawyers are encouraged to explain that it is common to have forgotten specifics of particular events and that witnesses should be upfront about the limits of their recollection. In a similar vein, the report provides guidance on how to conduct the back and forth that often forms part of the interviewing process. The task force suggests that counsel should resist the temptation to interpret a witness's responses and comment on how their evidence may affect their client's case. Particular care must be taken when summarizing a witness's answers. To some extent, condensing a lengthy monologue into a succinct, focused answer can be used in a witness statement, and indeed that may even be desirable or necessary, but lawyers should be mindful not to put their own spin on what is said. The report also addresses the use of contemporaneous documents when drafting witness statements. It recommends that counsel should obtain a witness's version of events before showing him or her any documents. And to the extent that any contemporaneous records are used to fill in gaps in the witness's own evidence, The report recommends expressly saying so in the witness statement. The report concludes with a number of suggestions aimed specifically at tribunals. The tribunal may give guidance at the case management conference as to how witness interviews should be conducted, how witness statements should be prepared, and to what extent witnesses may meet and discuss their evidence between themselves. And the report also identifies several steps the tribunal can take at the hearing itself to reduce the risk of evidence distortion, such as excluding witnesses from the hearing room until they're called to give evidence. I'd like to conclude with 3 brief observations about the report and its potential impact. First, its implications for English-seated arbitral practice. The ICC report and the recent Practice Direction 57AC of the English Civil Procedure Rules share a similar philosophical foundation, namely that human memory is a malleable state of perception that is vulnerable to being altered by a range of influences. Both documents seek to address how witness evidence can be enhanced in light of such vulnerability, and both offer broadly similar solutions. But there's arguably a sharp parting of the ways between the 2 documents in at least 2 important respects. Firstly, the task force's recommendations are heavily caveated and deliberately advisory. The report emphasises that the appropriate measures depend on the specific circumstances of each case, and that given the varying purposes of witness evidence, there can be no one-size-fits-all model. The ICC report stands in particular stark contrast to the much more prescriptive model adopted by the Practice Direction, which requires solicitors to confirm compliance with best practices identified and imposes sanctions for non-compliance. The task force also expressly recognises that in the international arbitration context, at least, witness statements are used for purposes beyond proving disputed facts. Interestingly, the task force concluded that those with a common law background tended to accept this wider approach to witness evidence more than those with a civil law background. By contrast, PD 57 is quite clear that a witness statement should be confined only to evidence as to matters of fact that must be proved at trial. Now, given the mandatory nature of PD 57 and how similar they are to many of the ICC's recommendations, it's not unreasonable to assume that the report's recommendations will be adopted, at least initially, to a greater degree in English-seated cases than elsewhere, particularly where there are English qualified counsel or arbitrators. My second observation relates to the ethical issues posed by the report for the arbitration community as a whole. The report concludes that it would be unethical for parties and counsel to take steps that would knowingly corrupt the memory of their witnesses in a way that supports their case. While that is undoubtedly true, the report's publication may prompt a wider ethical debate as to the responsibility of counsel and arbitrators to use their own initiative to better understand the functioning of human memory. The report recommended further training of counsel and arbitrators to reduce memory distortions in witness evidence, and it will be interesting to see if, in time, psychological training in witness memory becomes a mandatory requirement for those of us who practice in this area. Third and finally, the ICC report has already succeeded in prompting an important debate about the reliability of witness evidence, highlighting the significance of memory distortion in international arbitration and offering a wide range of practical solutions. Whether its recommendations will lead to modifications in current practice will depend to a large extent on whether tribunals are willing to take the lead in encouraging discussion of these issues between the parties at the case management conference stage. Thank you.
Thanks, Charlie. Jeremy, can I turn to you now? As Charlie has mentioned, this is, in one respect, quite an opportune moment to be considering this issue because in England, in English courts, in the business and property courts, there's been a recent reform of practice relating to witness statements. Could you tell us a bit more about that, and also in particular, whether that has any relevance to the practice of international arbitration?
Of course. Thank you, and hello to everyone. And as Ian and Charlie have said, I'm going to sort of have a deeper dive into the new rules that have been brought into play in the English courts. They're rules that only apply to the final trial or hearing witness statements. They don't apply to interim applications. And I think they arise out of there've been a number of interesting strands of comments from the judges in the English courts over the past few years. One strand is procedural, and the other to do is with the question of what witnesses really truly remember. Procedurally, to take an example from about 3 years ago, one of the construction judges, Mr. Justice Fraser, drew particular attention to the requirements of the rules. As lawyers, we all have to play by the rules. And he said that statements are not supposed to be drafted by those who equate length with substance and regardless of expertise with the copy and paste functions of the word processing programs. He said that witness statements shouldn't include lengthy quotations from contemporary documents. He said that if that was an attempt to impress the other side in adversarial proceedings, and that could be litigation or arbitration, with the weight of evidence in a party's favour, then as far as he was concerned, parties should think twice. And I think they're comments which broadly apply just as much to international arbitration as they do to litigation in the UK. The other issue is the issue that's been highlighted by Charlie and highlighted by the ICC report, and that's the question of the fallibility of memory. It's been running in the English courts for about 8-9 years, going back to a case called Guessman and a judge called Justice Leggett, who's now, I believe, in the Supreme Court. And the judge noted that two common and related errors are to suppose that the stronger and more vivid our feeling or experience of recollection is, the more likely the recollection is to be accurate, and that the more confident another person is in their recollection, the more likely their recollection is to be accurate. Now, I don't know about you, but that comment always makes me feel about politicians and the way they address what they think to be true. But the judge here, in the same way that the ICC have done, noted that there can be considerable interference with memory, which is introduced by the whole arbitration or litigation process, the way we prepare for trial, the way we prepare submissions. Witnesses are asked to make statements, often when a long time has passed since the events that were the subject of the dispute. Often statements are drafted by lawyers who know the significance of the issues in the case. Charlie was talking about the way in which we actually ask questions. The statement is made after witnesses' memory has been refreshed by reading documents. So the effect of all that is to establish in the mind of the witness that the matters in their statement and the other written material are true. And the witness's memory becomes based on this material, not their own original experience of the events. And that's one of the issues that the English rules are trying to address. And it's bang on with the issues that have been raised in the ICC report. Now, in the new rules, a trial witness statement must set out evidence of the matters that need to be proven at trial by the evidence of witnesses in relation to issues of fact. So it's a limited scope. Only set out matters of fact which the witness has personal knowledge of, and they've got to be relevant to the case. Identify by a list what documents the witness has referred to or been referred to in preparing their statement. And the purpose of this is to assist the judge in assessing the extent to which a statement is really the witness's own recollection, or whether it's based on the witness refreshing their memory. And the witness statement has to be signed by a new, improved statement of truth, which is worth discussing in full. The witness must say that they understand that the witness statement is to set out matters of fact of which they have personal knowledge. It's not the witness's function to argue the case or to take the documents through the court through documents in the case. The witness is setting out only their personal knowledge and recollection. The witness has stated honestly how well I recall matters and whether my memory has been refreshed by considering documents. The statement of truth ends. I've not been asked or encouraged by anyone to include in this statement anything that is not my own account to the best of my own ability and recollection. And finally, the witness statement must be endorsed by a statement of compliance signed by one of us, signed by a relevant legal representative, who by signing the statement confirms that the statement is being compiled in accordance with the rules. Now, this is all very new. It's only been in for a couple of months, and we don't know how the courts will test them. But I think we can guess from the comments from Judges Fraser and Leggett. And you can see one way where this is all leading. It's to a renewed reliance on contemporary documents. Now, I'm a construction lawyer. Many of the most widely used contracts, for example, FIDIC, place emphasis on the value of contemporary documents. The FIDIC contract talks about documents that are prepared or generated at the same time as the event giving rise to the claim. The contract also says that any award of additional payment shall take into account a failure to comply with that clause, a failure to actually keep the contemporary records. You can't catch things up with witness statements. Now, towards the end of 2019, there was a case in Australia. It's a court case, but arbitration. But I think you'll see the relevance. The judge said that a close examination of the actual evidence of what was happening on the ground would reveal if delay in approving the sewerage design actually delayed the project. The court should be looking to apply a common sense approach. Now, the judge rejected the witness statement from the site foreman. It was a generalized recollection of what had happened. What the judge liked was the primary contemporary source of evidence, the site diary. Now, this diary was maintained and updated every day. So it was being maintained and updated before anyone knew there was a claim. And it was also being maintained and updated as the situation evolved. It was therefore untainted by the litigation process. And I can see that an international arbitral panel may well have taken the same approach as the Australian court. And all the more so when you think about the length of arbitration hearings, rarely more than 2 weeks, usually much shorter. Tribunals can be sceptical of the value of lengthy cross-examination of witness. In part, perhaps this is because there's only a limited time. But also, if you already have full witness statements setting out the story, maybe a tribunal sees little value in repetition. And in any proceedings, court, arbitration, you want to think about the value of a statement. If it's simply a recitation of documents, it's not really going to be that helpful, I don't think. Tribunals want to know what a witness has to say, which is directly relevant to the issues in dispute. Who said what at a meeting that wasn't recorded? Why a comment recorded in an email was wrong? So I think I'm of the view that the UK's reforms to witness statements, it does have some relevance to the practice of international arbitration. The roots of the reforms lie in issues which have been raised by the ICC in their report. Do I think the ICC will follow the UK approach? Well, the easy answer is that it's too early to tell. But I think one of the points that Charlie raised, I think that the ICC report emphasises that training of both in-house counsel, external counsel, and also arbitrators is important to be able to understand the strengths and weaknesses of the recounting process, how to aid that process to ensure that the end product is as close as possible to an accurate understanding of what has happened. And as Charlie has said, that suggests the ICC is going to adopt a flexible approach, and that's in line with the ethos of party autonomy, which of course sits at the heart of the arbitration process. And there's the difference. It's the difference with the rigid prescriptive approach of the English court rules. Is that a cultural divide? I don't think so. Rules are rules and we follow them or don't at our peril, whether ICC or English civil procedural rules. And with witness evidence at their heart, everyone is beginning to come from the same place. So maybe change will naturally evolve as everybody recognises the value of contemporary documents. And one thing I think we should all quite carefully think about when we talk about contemporary documents is fake news. Think about records in today's age. Apps, databases, email, WhatsApp, Messenger, SMS, digital photos, drones. Is that too much information? Think about how the data is stored. It can be synced amongst project team members. It can be altered amongst project team members, including other organisations. How many times does someone have to say something is true for it to become true? How like an InDesign post, to confirm a tweet, to say I agree to an email, it becomes true, or at least the truth as a large group of people see it. Now that might be a digital example of witness memory distortion in action. So contemporary records will become increasingly important, as emphasised by the CPR rules and the ICC report. But the quid pro quo, I suspect, is that courts and tribunals will need to become very astute in judging the truth set out in those contemporary records. And who knows, maybe that means that witnesses will come back into fashion. Thank you.
Thanks, Jeremy. Very interesting. One of the things that you spoke about there, Anya, before I just turn to you, is the value of contemporary documents. And I remember in an arbitration award, the arbitrator quoting a Chinese proverb, apparently. I don't know if there's actually a Chinese proverb, but he said it was, that the faintest ink is stronger than the clearest memory. So with that, Anya, can I turn to you? As a dual qualified lawyer here and in Switzerland, is there a cultural divide, whether in relation to documents and witness evidence or witness statements, between civil lawyers and those with a common law background when it comes to the preparation of fact witness evidence? And if so, what might be the consequences for that and for arbitration generally?
Thanks, Ian. Well, it's a pleasure to be speaking on this panel today, and I have to say that this is segued very neatly into how I was going to start the presentation, because I do think that I don't think there's a fundamental divide. I do think, though, that it's fair to say that there is a tendency, both for litigation practitioners and for arbitration practitioners from a civil law background, to place more reliance on documentary evidence than they do on witness evidence. And I think it's been really interesting for me to hear about these developments, because it sounds a lot like what we are already practicing and have been practicing for several years. So I think it's going to be more a question of whether there is a recognition of existing practices and a shift, maybe a slight shift from one side, from common law towards civil law traditions. But to determine whether that's going to be the case, I'm going to take you to 2 points. And the first is goes essentially to what Jeremy has been talking about, and that is, do practices before state courts in state court litigation influence the practice of international arbitration? And I'll give you a Swiss perspective on that. And secondly, I'm going to briefly touch on the Prague rules, which have been touted as the civil law answer to the IBA rules on the taking of evidence, and see whether they really deal with witness evidence in a fundamentally different way. So for the first point, as I said, Swiss state courts do place much heavier reliance on documentary evidence than they do on witness evidence. And you're going to see that it's a completely different animal to what you might be used to in state court litigation in England. So in civil and commercial proceedings before Swiss state courts, you can indicate that you want to introduce witness evidence on a specific topic, and you do that simply by naming the witness after you've made a specific allegation. But there are no written witness statements whatsoever. They are simply not a recognised means of evidence. And so you refer to witness testimony, as I said, after a specific allegation, and you would tend to only do that if you don't have documentary evidence to back up that allegation. If there is a hearing, and again, fundamental difference, there is not always an oral hearing, especially in commercial cases that are often heard on paper only. If there is a hearing, the judge decides which witnesses to call and then is fully in charge of examining them, with the parties only able to ask follow-up questions. So as I've said, you can see that the background of all of this is very much to ensure that, we have untainted documentary evidence. And this goes a step further when it comes to dealing with witnesses in civil proceedings. Our conduct rules impose some very strict restrictions on contact with witnesses, both before and during the proceedings. And there's a distinction made between party representatives and witnesses. You can discuss the case with party representatives. You cannot freely discuss the case with a witness. This does pose quite some challenges if you're trying to find out what happened in any given case. And it doesn't mean that as a lawyer, you're not allowed to speak to a witness. But it does mean that if you do, there's a whole set of even more restrictive requirements than those that are being considered by the ICC and in England. You have to have essentially a third party present who can attest to the fact that you did not try to influence the witness in any way. You should draw up minutes of the meeting that could be discoverable. And you should hold the meeting in a neutral place. And essentially it's discouraged to the greatest degree to have any contact with witnesses before the proceedings. So this, as I said, fundamentally different system. How has that played out in arbitration? The bottom line is that it's not had a huge impact on the way in which Swiss practitioners, arbitration practitioners, use witness evidence in arbitration. In a Swiss-seated arbitration, or if you have a tribunal with Swiss arbitrators, you will still generally file witness statements. and the examination of the witnesses at the hearing would generally be according to the traditional common law model of short direct, cross, redirect by the parties' counsel. But it is true that if you have Swiss arbitrators, they also don't take too kindly to lengthy witness statements, that are essentially mini pleadings. They will tend to clamp down on cross-examination that simply leads the witness through the documents. And arbitrators might be more active in asking questions of witnesses. So there is definitely some influence to be felt there, but we're not in any way close to the practice before Swiss state courts. Other than in small cases, I've never seen an arbitration where there have been no witness statements whatsoever. As to contact with witnesses, there's a carve-out in our rules of conduct for international arbitration. So we are allowed to be in touch with witnesses freely. This has led to quite an interesting situation in a current case of mine where we have 5 arbitrations and 2 litigations in parallel, and we're scratching our heads a little bit as to what we're actually allowed to do or not allowed to do in those circumstances. So overall, I think it's fair to say that Swiss arbitration practitioners are influenced by the legal tradition before the state courts of affording less weight to witness evidence and more weight to documentary evidence, but it's not gone much further than that. Turning to the Prague rules, I mentioned that these are being sold as the civil law alternative to the IBA rules, and they were drawn up to address some of the concerns that we've just been hearing about regarding international arbitration proceedings becoming more overblown, but also very much to address concerns as to the way in which witness evidence was being used. Having examined the rules, and I have to add that I have never applied them in an arbitration, so I am very happy to hear if anyone has applied them and has a different view. I don't feel that they do differ quite as fundamentally as has been portrayed. There's no actual requirement to file a witness statement either under the Prague rules or under the IBA rules, although arguably under the IBA rules, it's a sort of presumption because they go on then to discuss the content of witness statements. The Prague rules provide for a default system, which I understand to be similar to the Swiss state court proceedings, where you name a witness and you say on what facts that witness will be giving evidence and why that is relevant. And witness statements can be filed, but this seems to be more of an exception. Another difference between the 2 sets of rules is the way in which they deal with oral witness testimony. Under the Prague rules, it's for the tribunal to decide which witnesses are to be called for examination, whereas under the IBA rules, it's for the parties to decide that. But again, the Prague rules also provide that if a party insists on calling a witness whose evidence has been relied on by the other side, as a general rule, the tribunal should call that witnesses. So I think it remains to be seen whether there really will be such a fundamental difference if these are applied in practice. In any case, I have to say there is a tendency in Swiss-seated arbitrations or with Swiss arbitrators not to apply any set of rules, either the IBA rules or other rules, strictly, but simply to refer to them as guidelines. And I'm sure that that's been the experience of many people here as well. So I think, again, it's fair to say the Prague rules do provide for a default system that does go towards the civil law tradition, and that the IBA guidelines were closer to a common law tradition. But I don't think there's a fundamental shift if you look at the 2. And that brings me to the question that we have here. Are we coming closer irrespective of the rules that we're applying, are we seeing a sort of shift towards streamlining witness evidence and maybe focusing more on its function as a fact, as evidence of fact, rather than the further functions that Charlie referred to before of telling a story or putting a personal spin on a party's case? I do think that that's a possibility. I think that certainly, as I say, a large number of practitioners, continental practitioners, were already using witness evidence in that way. And I think what's really important is going forward, and that's, I think, what Jeremy was also saying, to ensure that we take the best practices from all of these different jurisdictions or sources that we have, to ensure that arbitration remains efficient and flexible. Whether or not witnesses should only be considered as fact evidence, whether or not they should be able to tell a more personal story, I think that is something that should remain on a case-by-case basis. I don't think that we should be imposing very strict rules here. So I agree again with Jeremy, I think, in that respect. But it'll be interesting to see whether we do end up with a one-size-fits-all or not. Thanks.
Thanks, Anya. Really fascinating to get the other angle, the civil law angle on these points. Rob, you've been waiting very patiently. Can I turn to you next? We've been focusing reasonably tightly on witness statements at the moment, but could you just widen the discussion for us a little as to how Opus 2 is using technology to manage witness evidence?
Yes, of course, thank you. So thank you for your time today. My name is Rob Green and I'm the training manager for Opus 2. So I essentially look after all of the client training on the Opus 2 platform. So over the next few minutes, I'd like to give you an overview of how you could approach the life cycle of a witness throughout your proceedings, and what we refer to at Opus 2 as the connected witness life cycle. But just before we get onto that, for anyone here that's not familiar with Opus 2, we are legal technology experts that focus on connecting people. We help legal teams connect and collaborate seamlessly throughout the entire dispute resolution lifecycle. We enable lawyers to focus on the substantive issues of the case and achieving the best outcomes for clients, instead of being distracted by technology and how things are delivered. For more than a decade, we have worked with the top law firms in the world. We also collaborate closely with leading arbitration venues and organizations, including the ICC, who are kindly hosting us today. Our award-winning technology was the first cloud-based case analysis and preparation software. We're also unique in offering an end-to-end integrated solution for dispute proceedings. Since March 2020, we've also been at the forefront of delivering virtual and hybrid hearings globally. We're now approaching 1,000 hybrid and virtual hearings and have served over 630 clients worldwide. So just coming back to the witness lifecycle in dispute proceedings, we may categorize it broadly into 3 phases. Starting with the preparation phase, during which you may be working to finalize a witness statement. During this time, the legal team would capture notes, questions, and tag facts, and review these collaboratively, which may all feed into the preparation process. In some of our more sophisticated cases, with key witnesses, some legal teams have also extended a restricted platform access to witnesses, allowing them to add notes and respond to questions directly. Once the witness statement is finalized and uploaded back onto the Opus 2 platform, it is automatically hyperlinked to all of the related evidence. This can then be provided to the witness and, of course, to everyone else on the platform so they can complete their preparation ahead of the hearing. Finally, when the witness arrives to deliver their statement, the electronic presentation of evidence will display relevant key documents so that they are being examined on. The witness will see clean copies of the EP screens, providing a seamless and familiar experience. So now just going to dive into a demo to show you a high-level overview of how this works within the Opus 2 solution. So hopefully we can now see the homepage of the Opus 2 platform on screen. So essentially what we are kind of starting off here is just looking at the document set. So in this scenario, what we've done is we've given access supposedly to the witnesses to the platform. Now all of the material has been uploaded into this hearing bundle structure. But rather than rely on the witnesses having to kind of dive through this folder structure and try and find the documents that they are actually relevant to them within that list, and quite extensive kind of list of documents, what we've done is we've separated their material into what we call custom bundles. So custom bundles essentially allow you to group together key bits of material into an easy to access location, and it just simplifies things for the witnesses, meaning that they don't need to kind of delve through quite an extensive bundle to kind of find the relevant material. And as we can see here, for the witness that I created, Jonathan James, we have then just a list of materials that they will be kind of considering for their witness statement. As well as this, we also have created tags on the platform through the Manage Tags option. In this scenario, we are going to be collaborating with the witnesses, discussing certain points of fact with them. And so we've created kind of issue tags as a way of categorizing our observations to these certain topics. So let's just go and look at a document and an example of this type of collaboration. So here, if I just scroll down, we can see that this paragraph is starting here. There is a sentence there that I've originally highlighted and applied that issue 1 tag to. I've then also raised a question with the colleague or with the witness, Jonathan James, as to whether they think this figure is correct. And we've also then got a response. So Jonathan's been able to log into the platform, observe the question that I've posed, and then given me the response there. So we've basically been able to collaborate within the platform all in one kind of central location. So without having this type of collaboration done across different types of platforms and having to try and tie all this material together, it's all been done on that central Opus 2 platform. And these notes are not just found on the text of the documents themselves, can also come through to the notes report. And this kind of groups together all of this material, so it just becomes much easier to manage rather than remembering what documents you pose an initial question on. You can just come through to the notes section and see all of the questions and responses grouped together there. Once the statement is then created and uploaded onto the platform, as I mentioned earlier, it can then be hyperlinked. So all of the documents that are referred to within that witness's statement is then accessible from the actual text of the statement itself. So if we just come through into the witness statement section here, we can see there Jonathan James's statement here, and it has this links icon next to it. That's just telling me that there are hyperlinks within. So if I go into the document and we just scroll down, we can see in the body of the text there reference has been made to this document. And if we then left click on that reference, it then brings us straight into that document in its own separate tab. So this will be accessible for everyone who has access to the Opus 2 platform. These hyperlinks aren't just for your own party, it will be for the arbitrators as well. And it means that everyone will be able to then refer to these documents without having to cross-reference back and forth into the bundles each time they see a reference made to a particular document. They can just go straight to the relevant material. And then finally, for the actual hearing itself, when the witness is giving evidence. So usually what we would see at this time is that their access to the platform is restricted. So rather than being able to access documents with annotations and things like that, which is obviously a big no-no, they would just have the clean copy of the documents brought to them, basically displayed to them through the evidence presentation system. So in a face-to-face hearing, this would be literally a screen in front of them, which would just be displaying the documents that are referred to. And in the kind of virtual hearing scenario, very similar to how I'm sharing my screen with you now, and you're able to see the platform, the operator will be sharing their screen with just a view of the document that's being referred to at that time. So just coming back then, to wrap up, I hope you found the demo insightful and helpful to understand how an integrated platform solution can enhance the witness lifecycle. A lot of the features such as highlighting, notes, hyperlinking, and collaboration on documents are core capabilities within our platform, and similarly would enable many more applications and use cases. If you'd like to explore any of this further or would like a further demo or information, then please don't hesitate to get in contact with us. Thank you very much.
Rob, thanks very much for that. That's great. Okay, so we now turn to a Q&A session and the discussion. We've had some questions in, but this is also the opportunity for others. If you have any questions for our speakers, please do post them and I'll raise them. The first question, and I think, Jeremy, I'm going to ask you to deal with this one, is from Nehar Garg. And the question is, we are heading towards online dispute settlement through arbitration. And some might say we're already there. But how can the authenticity of witnesses and the tampering of evidence be dealt with in online mode? So how can the authenticity of witnesses and tampering of evidence be dealt with in online arbitrations? And indeed, any other comments, Jeremy, you've got about how online arbitrations and virtual hearings are going to impact on witness evidence?
I mean, it's a very good question that raises a number of sort of interesting, and when a lawyer says interesting, they really mean difficult issues. And I think there's two issues here. There's the idea of the virtual hearing. And I think that the last 15, 18, 16 months have shown that by and large, virtual hearings work well. Witnesses can be cross-examined. There's been some issues in relation to length of hearings. Perhaps there's another reason that hearings will get shorter, because everyone's recognizing the sort of it's difficult to run for the traditional full day. I think the question is really gearing towards seems to me to be gearing towards the online arbitration, perhaps when there's less scope for perhaps cross-examination. And I think in one sense the answer is very carefully is the way to deal with these things. And it means that those representing parties have got to be very astute to when they think there is an issue with the accuracy of the documents, and you're going to have to put in some kind of submission to explain that. When it's more, and I suppose I'm being led by the question, so there's the more issues in relation to, I don't know, some kind of fraudulent documents or forged documents or inaccurate documents. I mean, we have to deal with those today anyway. And I think that similar techniques would have to be used, and we'll just have to be addressing the tribunal with those. The more tricky one is witnesses. And if a witness is saying something that it isn't thought to be true in a statement, I mean, the way to do that is to flush that out through cross-examination. I can't think off the top of my head another real way of doing it. It's quite rare that you can do it. So this document is the golden egg, which demonstrates that particular witness isn't quite right in what they're saying. I think it's a caution, it's a concern, it's something sort of flagged up at the end of my talk. Really, not necessarily that I've got any answers, but I think people are going to have to be much cleverer in how they approach those issues, particularly in an online forum, because time becomes as a premium, and you've got to be able to get the points across closely. I'm conscious I'm not giving an answer because I don't know if there is one yet, and because it will depend on the nature of the problem with the documents and the witnesses, but everyone has to be a lot more alert to it.
Okay, thanks, Jeremy. Anya, I also want to ask you the next question, which is from Annabelle Gaberti. And Annabelle says that witness statements hold very limited value in civil law jurisdictions such as France, and that's something that you spoke of in terms of Switzerland. And she says, therefore, how would the ICC arbitrator deal with a request for witness statements from a party at an arbitration when the governing law or the form of the arbitration is, for example, France or French law? Would that arbitrator apply common law rules on witness statements in that instance? Could you comment on that for us?
Well, of course, I'll start with the usual lawyerly caveat that I can't exactly say, what the situation is under French law, but I would assume that it would be similar to what I was mentioning before under Swiss law, that you have a distinction between, if we're talking about conduct rules, of course, what you're allowed to do in litigation and arbitration. And from my experience of arbitrations that were seated in France, there's no direct application of French procedural law, even if there is application of substantive law. And so arbitrators would generally accept written witness statements. And I think they would take a similar approach to the one that I was describing that Swiss arbitrators take of accepting international standards. So you would have written witness statements, you would have oral witness evidence, but they would probably, again, similar to Swiss arbitrators, afford slightly less weight to witness evidence than they do to documentary evidence. I don't think they would apply strictly, again, common law rules. They would apply international practice, the IBA rules, and other similar guidance.
Yeah, okay, thank you. Charlie, we had a question from Michael Cottreley, which is that both the ICC report and the UK practice, the English practice direction that Jeremy spoke about, speak to a change in practice on the preparation of witness statements. And he says, should there be a corresponding change in how cross-examination is conducted, or how witness evidence is assessed by the tribunal? And if so, what might that look like?
Sure. I mean, there's a lot in this question, so I'd just like to unpack it a little bit, and it's a fascinating question. I mean, the first issue is, should there be a corresponding change in how cross-examination is conducted? I think there's really two ways to approach that. I mean, the first is that that you take that to mean that the heightened awareness of how questions are asked and how that impacts on a witness's honest memory is an incredibly, it's both a valuable tool, but it's also one that needs to be used consciously by counsel, both in the context of preparing their own witness and also in the context of cross-examination. So I do think that this is going to lead to some interesting debates as to the value of evidence that is adduced on cross-examination. When one sees, for example, how a witness can be influenced merely by how a question is asked, I do think there will be a heightened awareness from tribunals, judges, lawyers, as to the value of any evidence that is adduced by a lawyer asking a crafty question in a particularly leading way. And interestingly, the ICC report does touch on this, and it says it's beyond the scope of their remit, but something that they've actively encouraged others to look at. So I think watch this space. I think the other issue with how cross-examination is conducted is whether the ICC report, and indeed these other reforms we've been talking about, give cross-examining counsel a further weapon to use during cross-examination. I mean, one could imagine during cross-examination certain scientific studies being rolled out and put to witnesses in order to get them to confirm that their memory of an event that took place 5 or 10 years ago is entirely unreliable. So again, I think watch this space. The second part of the question is how witness evidence is assessed by the tribunal. I'll just be brief about this. I think there's a danger that the ICC report is misinterpreted to be that there is something inherently unreliable about witness evidence and therefore it should be second best to contemporaneous documents. That's certainly something that the authors of the ICC report were at pains to avoid, and they specifically said that that's not how they wanted witness evidence to be perceived. I do think there is a danger, though, that the skepticism that has been adduced in both the ICC report and in the UK's practice direction will lead tribunals to conclude that witness evidence generally is less reliable than certain contemporaneous documents, although I don't think we can generalize when we're talking about contemporaneous documents. For example, a contemporaneous meeting minute that is just authored by one party and isn't signed by the other party is, could be their way of putting a spin on events just as much as a witness puts spin on events. So, as I say, a lot going on with that question. I think that could even be the topic of an entirely different debate. But hopefully, I've answered it.
Thanks, Charlie. Just following up on that, we have a further question from Andrew Stevens. I want to put first half to Jeremy and the second half to Anya. The first half is, isn't it key that counsel conducting cross-examination in international arbitration, whether that's before common lawyers or civil law lawyers, should focus on the most important issues and be brave? And I focus from the start of the cross-examination on key issues that will matter to the tribunal's decision and not on peripheral or jury points or going through documents for the sake of going through it. Doesn't that solve that problem, and isn't that the way to do it, Jeremy?
Simple answer, absolutely. Yes, it is. I mean, and I think it's what those cross-examining witnesses do. And I think it's where the UK rules and the ICC report and everything else is driving. You want to focus on the best key points because they're the points that you want to get across, or you want to get across to the tribunal. And yes, in part, it might be governed by the fact you've got a short hearing, you've only got an hour, 2 hours to cross-examine a witness. Therefore, you focus on the key elements, and that must be the right approach.
Thanks. Anya, the second part of the question, just building on that, was, doesn't that also deal with the problems created by having short hearings? And wouldn't it put a civil law arbitrator, I think it means, wouldn't it convince a civil law arbitrator at least that cross-examination is actually useful? So I suppose this is testing perhaps how far the process should go in adopting a more truncated, what you might call streamlined procedure akin to civil law proceedings. Isn't focused cross-examination, even in a civil law arbitration, the way to deal with witness statements in a way which is actually useful and inherently useful to the process?
Well, I'll also say absolutely. And I think that's exactly, I mean, it's what should already be happening. It's what I do see happening in many cases. And when I was talking before about arbitrators stepping in, that's generally how and when they step in. They might do it at the beginning of the proceedings by including things in the specific procedural rules that give an indication that they want the examination of the witnesses to be focused on specific issues of fact, and not to go into overly broad pleading style or cross-examinations. And then just on the question of does that deal with the problem created by having short hearings, I have to smile a little bit, because you have to be aware that for civil law practitioners, a 2-week-long hearing is a long hearing. And that, examination of witnesses over several days is not something that happens on a regular basis. So yes, I completely agree that focused cross-examination and really concentrating on key points that you want to get across is the way to go. And it's what is already expected, I would say, by a lot of civil law arbitrators.
Just in the last few minutes, Charlie, we've got one final question I just want to raise with you, which is from Kim Franklin, QC. And the question is, how do the reforms affect statements given by witnesses in their non-native language, where there is a contrast in their written and spoken command of the language? Do the reforms affect that?
Well, with regards to the ICC report, I think the answer is broadly no. The ICC report recognizes that as a practical matter in certain circumstances, lawyers will need to get more involved in the witness preparation and the drafting process than would be the case if one was dealing with a very sophisticated witness. They also actually talk about a circumstance where you might be preparing a witness statement of a very busy executive who wouldn't necessarily have the time to sit down and draft his or her witness statement. And again, the ICC report recognises expressly in those circumstances that the recommendations that they put forward have to cede ground to practical reality. And that in circumstances like that, and again in circumstances such as where a witness is being asked to draft a statement that isn't in their native language, then the involvement of counsel will indeed need to be greater. So I think that the reforms are practical suggestions with a recognition that in circumstances, in certain circumstances, they may not be entirely appropriate, and this would be one of them.
Brilliant. Thanks, Charlie. I think we are now at 10 o'clock, so I will bring this to a close before I hand over to Natalie. Many, many thanks to our speakers. Thank you to you all out there. Thank you to those that posed questions, and have a great rest of your day. Natalie.
Thanks, Ian. Thanks, everyone. And yeah, thank you for all of your wonderful questions. I'm sure we could have kept going for a little bit longer, but time has beaten us. So the next session takes place at 12 o'clock. We're going to be talking about dealing with expertise, the opportunities and challenges of expert witnesses in international arbitration, and using expert evidence in cross-examination in arbitrations in multiple jurisdictions. It's a YAF workshop, so do join at 12 o'clock. For those that are interested, you can log on to the virtual platform and join live. The next session after that will then take place at 4:30, and we'll be looking at introduction to enforcement of arbitral awards in offshore jurisdictions. So we've got 2 more webinars coming up this afternoon, and we hope to see you all there. Thank you ever so much, guys, and hopefully see you in person soon. Take care. Bye.